You maintained that the two of you both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
Correct.
And then when Ms. Love read it out orally in the court, and Mr. Sledge, one by one, said, yes, I acknowledge that somehow that didn't occur to you at that point in time either, was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and Mr. Sledge, one by one, said, yes, I acknowledge that somehow that didn't occur to you at that point in time either.
When I heard that, that's when I knew they finna make an example out of you, man.
If you're new, make sure y'all hit that notification bell, that like, share, comment, and subscribe. Grab a seat, we finna dig deep.
What's up, YouTube family? Welcome back to the channel. Man, I'm your host, Jay, and y'all know we back with an exclusive update and shocking turn of events, and it's Young Thug, ysltrial. Now, did I not say that it was gonna happen? Did I not tell everybody that the state was gonna turn around and target the witness that got up there playing on the stand when it came to these pleas? Because it didn't go with the state's narrative? Well, today, it actually happened. Today, the star witness was actually taken into custody after coming back to court for a motion hearing for probation revocation. And man, the state made an example out of this defendant. They revoked his probation and gave him 5 years. Now, what happened? Y'all know we about to dig deep so we can break it all down. But before we dig deep, man, y'all tap that like button whether you're a fan of the case or fan of the state. Tap the like button. That helps the channel continue to grow. Subscribe to the channel if you're not subscribed, and definitely tap that notification bell so you won't miss a drop whenever we drop. Y'all ready? Let's dig.
All right. This is a probation revocation matter.
Yes, Judge. State filed a notice of a probation revocation for the defendant as to his violation of a special condition within the sentence that he received from Judge Glanville on December 8th of 2023 as it relates to his reviewing, acknowledging that the factual acknowledgments that were a part of the plea agreement in which he entered into on December 8th of 2023. I have a certified copy of the conviction for Your Honor with a certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8th of 2023. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he, again, understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3. As everyone is aware, Your Honor witnessed it and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea agreement during the testimony for him to focus on and read and to go one by one and acknowledge or disavow is the only word I could really think as to being no longer true and testifying under oath that he was violating the special conditions of his probation, Your Honor.
You seated or?
It's probably easy. You can. It's probably easier to hear you that way.
See, I had to stop it right here. Did you hear that? This the attorney's approach. You comfortable? And you got this man facing time in jail for stuff he already took a plea on? And your first question is, can you stay seated? Absolutely not. if you were my attorney, I'd have asked you to stand up because you're representing my freedom, my life at this point. Can you stay seated? I'm uncomfortable, but you getting comfortable? Mate, let's dig.
Okay, I think I'm on. Your Honor, if it'll please the court, I believe, and I already sent to the court defendants 1 through 6. Defendants 1 through 5, I believe, were already, I think my emails between myself and Ms. Love came into evidence during our testimony.
Came into evidence in the trial of the defendants that are on trial right now.
Yes, Your Honor.
Yes.
So those are sort of resubmissions
Okay.
of those, but I do think they're already before the court, or the court can potentially take judicial notice of that.
What is your Exhibit 6? I think I
Well,
only got 5.
Exhibit 6 is the one thing, and that's just a listing of my emails in December between
Oh,
myself
that's
and Ms.
this one
Love.
page?
Yes.
Okay, it didn't have an exhibit marker on it.
I'm sorry,
so
Judge.
that's fine.
And so succinctly, I thought it best to submit these exhibits. When you look at Exhibits 1,
And those are admitted for purposes of this record, which is the probation revocation matter.
Thank you, Judge. When you look at Exhibits 1 and 2, what you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours, and that's one reason I wanted to make sure that the sort of the cover page along with the attachment are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that a second one, Defendants 2, comes in at 5:06 p.m. And at some point I respond. Those are the only 2 exhibits or the 2 drafts which occur on the 27th. However, it's important to note that when you see the response that I send to the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right. Yeah,
Now,
and I recall we discussed this during the trial of this, the ongoing trial as well.
yes, Your Honor. And the point I won't belabor it is these revisions you actually see being put into the drafts. So by the time you see Defendants 3 and Defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was Defendant's Exhibit 4 that if you look on Defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. And remind you, on the 28th, we're in court. This isn't where I'm at my office. I can print it out, look at it, take it to the client like we did on the 27th. On the 28th.
On the 28th, both you and Mr. Sledge are in person in this courthouse, right?
Correct. So the emails, if you notice, I never respond because I'm here. I'm in person.
Right. I will
testified.
take judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood. So ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things, we said he'll have a chance to answer the question and to explain. Now, there was a big problem, and I noted in my testimony that number 8 on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim. And therefore, number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that that statement was false. That is,
Yeah, I'm not sure about that. That may be your contention, but
well, we would contend to the court that where my actual email, Defendants 2, clearly denoted that.
it does not. That is up for debate what that denotes.
It is removed from all the drafts and then ends up back in.
That is true.
So
But your response on your Defendant's Exhibit 2 to what is then item number 4 does not definitively state anything like what you just said. He said he did not know, as we discussed at the time of the ongoing trial, was could have been interpreted in several different ways. But I understand what you're saying.
And just so I
You maintain that the two of you both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
Correct.
And then when Ms. Love read it out orally in the court, and Mr. Sledge, one by one, said, yes, I acknowledge that somehow that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to, he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, et cetera. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and then the part 5, sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands and he's had an opportunity to discuss it and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that.
that is something that it was understood, understanding it's not in the written plea agreement, but it was understood. And the other thing to also take note of, my client, when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who was now, after, what was that, December of 22, was now, for the first time, being drilled or asked questions, rather, as to the specifics.
See, this is a prime example of trying to make a deal with the devil. Now, he knew what he signed up for because he put his initials on that paper. Now, some would say, hey, maybe number 8 was changed, but as you just heard, all the other different violations. So again, the state did what? Played on verbiage and understanding. Now, if you sit up and listen to his attorney with all these excuses that absolutely mean nothing at this point, ask yourself this: why does it sound like both of them had no understanding? Or did one person have understanding and the other person didn't? This attorney, in my personal opinion, is just too relaxed. They knew what they were doing before they got into this courtroom today. I mean, that's just my personal opinion. He knew how much time he might possibly get. Who knows? But you telling me out of all this paperwork and all this time, even since it initially happened when it first got brought to your revelation after you missed it together, you telling me now, while we sitting here watching this man fight for his freedom, while the other defendants fighting for their freedom, you got this whole discovery paperwork and you only focus on number 8? This man just got a whole nother slew of different acts that violate this actual plea agreement? So I knew at this point, this man was in trouble. Let's dig.
Of all the things that he had allocated, all the questions that were going to be asked, there was no preparation of him. So what you saw was probably frustration on his part at times and shutting down at times on his part. But it was also part of the manifestation of what happens when a witness who's not a lawyer, who's not someone used to this, is getting questions fired at them. And at some point, I think the court can take note that he literally shut down. And some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say something different than what ultimately he allocated initially. So,
Give me a quick rundown of what this defendant's prior history is, including any prior probation violations. All right. Hello, Officer Jolly.
Hello, Judge.
Recommendation in this case?
Due to the last minute notification of this probation revocation, I would leave that up to the courts to make that decision.
Okay. All right. Well, I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right. Well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked. Is that right? All of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years, so he would have 26 and change or 25 and change.
I'm sorry, correct that, 22.
My bad.
That would be 27 years, 7 months, and 8 days.
All right. All right, thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Okay.
Your Honor, if it will please the court, I understand the court's ruling that there is a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation. And I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing acknowledgments, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation, but I also appreciate the fact that some of the many why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation, and the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble in and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And
And he will
reinstating
be
the
continued on probation, Your Honor?
Yeah, and reinstate balance.
Your Honor,
Thank you.
might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So, no, I'm sorry. All right, court is adjourned.
Good seeing you, Judge Whitaker.
Yes, thank you. Good to see you.
All right.
The only person we could hear was Miss Jolly, so the only person we could hear was Miss Jolly.
Oh, wow.
Not on Zoom.
I don't know, the sound in
Y'all
this
be at
courtroom
that.
is...
Go to the next room.
Nah, it's tough. This man just got 5 years. Imagine this, doing your time, being free, signing the plea, and back in jail. 5 years with a 15 relationship built with this attorney that's in here defending you, that's comfortably sitting down with his Dr. Scholl's shoes on, because he's comfortable. This man just got you very comfortable to actually go to jail for 5 years. Now, luckily, the judge did actually cut his time in half because she actually could have gave him the whole 10. Now, a lot of people say he was facing 30, so 5 isn't anything. But ask yourself this, is the state making an example out of this witness? Is this an actual warning to those actual witnesses that came up here and played on the stand with those pleas? Let that sink in. Now, it's interesting because now you have to ask yourself, how will this actually impact the trial? Now, the state is doing any and everything that they can just to try to get any defendant to flip. We watched all week, all of the witnesses actually made the state's story and narrative just fall apart. So is this what the state is doing? Are they trying to use this actual defendant with his sentence and his plea to actually get him to flip and start actually telling what's going on? Make that make sense. Now, they really need somebody on the inside to actually do some talking, to actually come up here and try to help get the state's narrative back on track with this case. Because right now, the case is everywhere. But as you've seen, they are willing to sentence anybody at any time that had anything to do with this trial. So was the judge fair? Was the sentencing fair? Was he screwed from the beginning? His attorney knew, in my personal opinion, that he was screwed. He fumbled, didn't check the paperwork. You didn't even take the time to go back and go through this man's plea after all this time because you stuck on number 8. The judge just literally slaughtered him and just slaughtered this defendant. Man, y'all jump in the comments, let me know y'all's thoughts. So much more to come this weekend, man. We got a lot of stuff to talk about. We got to talk about that Y-Fan Lucha, that Yak Got It, the YSL. We got to put it all together and make it make sense. Man, was this a blow to the case or just a blow to the defendant for actually taking away that actual plea and signing with the state? Man, until next time, this right here is an example of the life you saved might be your very own. Till next time, man, y'all jump in the comments, let me know y'all's thoughts. Did the judge get it right? Did the judge get it wrong? Till next time, I'm your host, Jay. Gone.